Hey everyone, Anthony Fantano here, internet's busiest music nerd. Hope you're doing well. And here we have, yes, yet again on this channel, another AI video. But you know what? I couldn't keep myself from addressing this topic again because there's actually like a lot of important things happening on the legal front with generative music AI right now. For example, Warner Music Group just settled a $500 million copyright infringement lawsuit that they had against Suno. Then also, UMG, Sony, and Warner just struck a licensing deal with this up-and-coming generative music AI platform, Clay, where presumably they are going to allow that platform to essentially train its AI on their music through, again, this licensing deal where there's going to be payments and royalties and so on and so forth, which, like it or not, this is only going to further normalize generative AI in the music world. And also, in addition to all of that, friend of the channel, Miss Crystal, aka Top Music Attorney, has recently brought Suno to court with a class action lawsuit on behalf of countless independent artists who, up until this point, have been getting little to no legal representation in this music generative AI war zone. And her suit has gotten to the point where now Suno has actually filed a dismissal of some of their claims. And so with that progression of events, I thought it would be a good idea to come on here and have a conversation with Miss Crystal and talk about these topics, the state of music AI right now legally, and the progression of this lawsuit. So here we go. Here we are with Miss Crystal. It's been a minute. I've been wanting to talk with you since your firm initiated this lawsuit against Suno, and now we've gotten to a point where I feel like we have to have this conversation because there have been some interesting developments that we will get into as well, and I wanted to use this as a chance to just kind of talk about a lot of the legal fronts on the AI topic right now. As you know, like we do discuss this topic a lot on my channel, but it's mostly through the lens of like, you know, just kind of music critique, concerns just from like the fan perspective. We're not always able to dive into like the legal side of this as much as we would like to. But now that you're here, we can do exactly that. So, you know, kind of start to paint a picture in terms of like the nature of this lawsuit that you guys have filed, as you've said on, you know, different platforms, like on behalf of, or, you know, in support of independent artists. Is this a class action? Are you representing specific artists as you kind of pursue what you're pursuing here? You know, just tell us the impetus and the start of this lawsuit and the approach that you guys are taking.
You got it. Class action lawsuits against Suno and Udio. And I would say if you're an independent music maker, right, producer, an artist, please listen up. I'll make sure to say this later on in our conversation as far as, you know, how you get involved. Because here's the thing. If and when we win, there's going to be a pot of money. And I need as many people who had their music on music platforms, which means not just Spotify and YouTube, but literally your own websites in the last couple of years. If that is you, you qualify. So please, you know, stay tuned. But these are class action lawsuits on behalf of all independent music creators. We have been at it for 5 months. I can't believe this amount of time has gone by already. We've put in hundreds of hours already on this because these are like cutting edge issues on IP, AI, and now it's the DMCA. But anyway, so, you know, as far as where we're at right now, we have amended complaints, and we'll talk about with Suno. They filed a motion to dismiss. So they're trying to get a huge chunk of our complaint kicked out right away. It's not the whole thing. It's only a part, and we responded. So that's kind of where we're at right now.
Who are some of the artists that you've specifically connected with to do this? Because I know there are like some singular examples that your firm has brought up in this case in terms of like, you know, this is the music that your platform is creating, spitting out, generating through whatever processes that you are. And it's sounding exactly like this song, this piece of music, this vocal from my client here who I'm working with in the, you know, on the representation side, but also in the digging that you guys have been doing. How many of these like specific instances are you catching where you're seeing like these extreme similarities?
Yeah, because we're saying a couple things. We're like, there was an infringement because you took tens of millions of songs without authorization. There was infringement because then also your AI created lookalike songs. And so in the examples we pointed to over 100 examples where all these different independent sources were like, hey, we just saw Suno do this. We just saw Udio do that. So we cited to all of them, but actually 2 months before we filed our amended complaint, in the Suno case, someone messaged me, right? One of our followers, and he goes, one of the songs that Suno spit out had Zaytoven's, the music producer sample in the new output. So the point just being like it's a continued thing. So that's why we just like we're like, this is when Suno came and filed its motion to dismiss, like, you can't prove that Suno has ever created something based on the music it was trained on. We pointed to 100 different examples. What are you talking about?
Yeah, and also, like, I mean, again, you've been doing this digging. I mean, I know in broader conversation around these topics and in doing research on the platform myself in videos that I've done, like I've seen either this or hints of this, but like, does Suno and a lot of these AI generation platforms themselves acknowledge the fact that, like, in order for them to do what they do, they have to train their models on other music that is created by people? Or are they not acting like that's the case still? Or are they just pretending this is all magic and this music that's being generated is just coming out of nowhere?
I actually think that this was a mistake that the attorneys made. This is my perspective. But I think in the beginning, when they first started getting accused, when both companies came back, they initially didn't say, right, in response to the accusation, you've taken music and you didn't get it licensed, you didn't buy it, you took it without authorization. So that was the accusation. But at some point, they both came back and they're like, yeah, we did. And in fact, and they were so, they were emboldened in their response, and they're like, we took it. In Suno's case, it literally said we took tens of millions of songs, which of course, right, by far a majority are going to be independent creators. So they very much have addressed it. And I think that was a mistake made either by the lawyers or the representatives. I don't know, but someone made that decision. And then we learned about it and here we are.
Okay, so once you sort of like have that admission or that paper trail sort of like showing that, what is exactly upon you guys as, the plaintiffs here? What's your burden to prove to the judge past that point in terms of like either proving damages or legal precedents that you're trying to set through this case?
Yeah, so for the first one on you trained without authorization, they've already admitted it. They can't walk that back. So that's the piece that they're not fighting right now with the motion to dismiss, at least with Suno. So what they're saying is that it's fair use. Okay, we've talked about this a lot, but something, if it's
right,
fair
so they're not fighting it, but they're validating it. They're trying to sort of like say, well, it's actually okay because.
Yeah, it's justified. It's justified. So that's what they're saying, fair use. And then for the second piece on, did the AI duplicate? Did it, recreate producer tags? Did it, redo compositions? And they're just saying no. And in fact, that's not even how it works, right? So that's their position as of now. So our proof, a part of it, is going to be that we need to point to some of the outputs. And this is where it gets tricky when you're talking about something that generates hundreds of thousands of outputs, a week. Right. But, the way I've said it, I'm like, just because it's going to be hard doesn't mean we're not going to have the fight, because we have proof this is what the AI not only was doing, but it was designed to do this. Because like in Suno's case, the CEO, put out, he did interviews where he specifically said that our AI is already capable of literally doing lookalike voices and songs of other artists. We just haven't rolled it out because of the legal landscape.
Right. I mean, you would think, or at least I would think, again, as an outsider here, that the battle with this wouldn't be so uphill, considering the fact that there's like already all this legal precedent when it comes to humans and labels and rights holders suing other humans, labels, and rights holders over just very basic similarities from song to song, two different copyrighted songs. Like, why is it not as easy to basically say, in the same sense, like, hey, I'm a rights holder, I'm a label, I'm an independent songwriter. Your platform literally just spat out a song that sounds exactly like my song, and basically make the same case. What is there sort of a disconnect there, or an obstacle to overcome?
Yeah, it seems like for me, as a copyright litigator, that's exactly it. I'm like, we go to war over a couple of notes being very similar.
Right, exactly. Even just a vibe of a beat or something.
Yeah, so to be like, and we have these examples where like the output was very much almost exactly like, the thing that it had trained on, all the stuff. So there seems to be a little bit of a disconnect, and I can't, speak to that. But going to one of the other claims, it's the DMCA. So DMCA is a different violation under the law. It's not copyright. Right? It's under the same thing, but it's a different thing altogether. So what it says is that if you go and you break through technological barriers, so let's pretend you have a website and there's a password. I have to pay you to get on your website. If
Right.
I, in my, genius software hacking, get through this without having to pay you anything, that would be a violation of the DMCA. And so we're also fighting about that because, both platforms came out and they're like, we scrubbed on YouTube. We downloaded a bunch of stuff. And in fact, let me strike that. They didn't come out. Billboard exposed them. Anyway,
Okay,
so
okay.
they scrubbed off of YouTube, and so we're alleging that they broke through the technological barriers on YouTube to download. And so it's this big fight. And so, part of the proof is going to be, again, in discovery, we have to, how did they break through? How did they get copies of the videos? How did they then take the audio files out of the videos to train the AI?
Great. Well, sorry, right. And from what I understand, in the dismissal that you guys are now dealing with, they're trying to prevent you from like looking into their backend and finding out that exact information.
Yeah, they're trying, the lawyers are trying to assert procedural, things. And they're like, Judge, you need to kick out, 3 of the 4 claims altogether. Don't even let them do discovery to try to find those outputs, right? That, for our lead plaintiff, Tony Justice, we don't even want you to let them do that because you know what? We don't think they've said enough in their complaint to get past this stage. And I'm like, 70 pages of, drafting, 40 hours on this thing. We did.
Right. What else, just to kind of like let the audience know, what else in, your suit are they trying to throw out here in their dismissal? Like what are their, kind of like biggest contentions here?
Yeah, they were also attacking our unfair competition claim. So we also are bringing it under Tennessee, which is where, again, our lead plaintiff is based. And again, this is something different than copyright infringement. So unfair competition goes to if someone has labored to create music, to create something, they are entitled to get that license to benefit from their business investment, right? So our music creators and their music. And so again, unfair competition, just saying this is not the same thing as copyright violation. And so right now they're trying to attack that as well.
And what the theory behind that being, we're going to sue on this basis under the idea that like your platform allows for my, sort of client song or music to be sort of like endlessly copied a million times. So therefore the value of what they do drops merely by the fact that like in a snap, your platform can, create maybe 200 different variations of this thing my client is trying to build a livelihood off of.
Yeah, pretty much. And the argument is one of them anyway, is it's preemption. So under copyright, a claimant is prevented from like double dipping. So if you're going to bring copyright infringement, you don't get to also bring a state law claim of unfair competition. So that's part of what they're arguing. They're saying this is just the same thing as copyright. We're saying no, it's not. We're saying this is actually having to do with the labor, the creation of it's not because you just copied it and created a new version. So that's a part of the argument. But you said it nicely, that it's really over the labor of creating and having services and brands because, part of the examples we gave were the producer tags, that we were having exact producer tags ending up in new outputs. That's someone's brand. That has nothing to do with copyright. That's a misidentification of who created it. The reason of the producer tag is to be a source identifier of who created the song.
Yeah, and it's I think like pretty key in terms of bolstering the idea and the argument that like what these platforms are doing is merely just like kind of in its own weird way remixing pre-existing music from the very people you're trying to defend. It's not like coming up with a wholly original and totally different out of left field composition that was like never before thought of.
Right. Exactly.
What else are they kind of like either trying to throw out or sidestep in terms of like your claims here that you're making in the suit?
Well, in the DMCA context, one of the arguments is that they go, Judge, you got to throw this out because us going onto YouTube downloading videos or however they got access. I don't know how they got access to all the videos and the songs. They go, that's just us making copies. In order for us to make copies, we were just engaging in fair use. Now, this is where it gets convoluted, okay? But let me try to give clarity on this. So them being like us little YouTubers going and downloading videos so we can do reactions to them, like trying to compare to what someone can like be, oh, that makes sense. We are YouTubers. We create videos, we do reactions. And so what they're trying to do is kind of muddy the waters and confuse the issues. And Congress, actually, in the legislative history of this, Congress came up with this whole new thing called the DMCA so that you could bring an action for someone breaking through technological barriers to get access. It has nothing to do with copyright, it has nothing to do with fair use. And one of the arguments that I made that no one else has made in, our kind of sister cases of what's going on here is I'm like, you can go on YouTube and use OBS to record your screen. You don't have to download a video to make fair use, and you don't have to break through anything. So, right. I tried to, this is where it gets complicated because, I don't know how much the judge uses YouTube and does reaction videos, you know what I mean? But in trying to explain that even when they're saying fair use, it fails because that's not the law. But even if the judge is like, I buy it, I go, well, that's not the only way and the primary way that people make fair use of YouTube videos. You can, and not break through any technological barriers to do that.
Does this not also sort of like, break the fair use argument by virtue of the fact that, Suno is kind of like recreating all of these works in, obviously a commercial endeavor. Like people are paying for access to the platform. And if not, merely on Suno's side, you have people who are individually sort of using it to create art around a certain artist, maybe they've created or whatever they have in their own head, and are then trying to sort of like, have that music stream or sell on other platforms. Like, does it not also sort of not qualify as fair use because it's not just being done for opinion or remixing and stuff like that? Or am I misunderstanding a little bit?
Well, no, and actually the Copyright Office came out and talked about this, and the Copyright Office in May put out a report, and the Copyright Office goes, it totally matters to the fair use analysis what you took and what you created. If you took something that is expressive, that's very creative, right? It's music, it's books, it's art. That gets more protection under the law in general, okay? So they go, all right, it's expressive to then make the exact same product. Take music to make music. In the eyes of the Copyright Office, what they say is they go, that's probably not fair use. So it totally matters.
Hopping into, I guess, maybe like, the judge topic, not specifically the judge who, you're obviously dealing with in the case, because, obviously that's probably something that you don't want to dive too deeply into. But, in your experience in the legal world around these topics, though, like how much of your success here and how much difficulty do you see yourself and other people facing when it comes to trying to get judges and get people in positions of legal authority to like understand what's going on here? Like, have the waters been muddied to the point where it's difficult to like get people to understand what exactly is happening? Because this is, as a lot of people kind of see it, like new and confusing, weird technology, or, are the facts of the matter like a little more plain as day as we may presume?
No, and in fact, because it can be convoluted, it can be so complicated, and then try to explain music and how that works on top of the law, So right. One, the good news is that these are federal cases. Because they're federal cases, federal judges are often great. They're like top tier, smarty pants. They're going to get it if anyone's
we want the most smarty pants judges. Yeah, the most smarty pants judges we can get our hands on, yeah.
Thank goodness. So that's one. That's good. But equally, there's an argument, and the major record label lawyers have said that, part of the reason why they only have sought copyright infringement for downloading the music. That's it. There's all these other claims that they could be going after, but they're keeping it simple because it's a strategy thing. And for us, we added a couple other things. We have a number of things we didn't add for the same reason. We don't want to overcomplicate this because it's already complicated. So it's important. But let me tell you, in our, amended complaint, that's why I cite all the different judges in all the different courts who have ruled on this and been like, this is BS. These companies that have gone and just stolen what is not theirs. And so you kind of do that to be persuasive to the court and be like, look, these are other judges. This is what they have to say. Don't listen to me. Listen to them.
Right. I mean, recently there was a pretty big settlement that a couple of the major labels just kind of reached and agreed to with Suno in the midst of a lawsuit that they filed. Does that resolution at all give you a bit of solace or peace in mind in terms of what you're doing? Do you see many parallels between your case, their case, and does it make you hopeful for a certain outcome that you're searching for on your end in doing this?
It makes me interested on where we're going to land because a big reason we did this is we were excited to set case law. So that means we need to get to a place where we set case law. And so settling early can be good, but sometimes it prevents us from having, reaching that end goal. So I will say, so between Suno and Udio, Udio was the one that settled first with Universal, and then it settled with Warner. And so that's not all the majors, right? So we still have, Sony. And that lawsuit's still going. But that's interesting to me in that they are realizing what they did or otherwise just seeing that it's not sustainable to just take what's not yours. And then you have to deal with lawsuits. Like they should have done this the right way in the beginning, but that's also partly what happens in lawsuits. You didn't do it the right way first, you got sued, and then you now have to figure out what you're going to do moving forward. So, is this going to be the same for Suno? We'll see, because Suno's in a different position. I don't know if you saw this, but Suno's new valuation that it's doing for its new round of investment raises is like 2.4 billion. Right. And so that's an increase from 2 billion of where they were at like a month and a half ago.
Right.
So,
go on.
I was just going to say, so in the, some people are nervous. They're like, are these lawsuits going to ruin these platforms and shut them down and whatever? I'm like, I don't think so. They're so far ahead. But one of the big things, and I don't know if you saw this, but, Udio made it so you cannot download your outputs anymore. And so, arguably that's because of the settlement agreement terms and all that. But, that really pissed off the Udio users, understandably.
Right.
That's why they're using it.
Yeah, that's a pretty big paradigm shift in terms of how people use their platform.
Yeah. And what I think, we'll see what happens, but what I think is going to happen is that I think in order for Udio and any other companies, let's say if Suno does take on something like that, they just need to team up with distributors. So if they just make the pipeline, they go make it on our platform, then you distribute it, then you don't need to download anything. So it resolves the issue. So we'll see what happens. But
just to put it in plainer and more direct terms, I mean, aside from the monetary damages that, you're seeking to, that you're seeking here, because you just kind of made reference to it with the whole case law thing. What kind of legal precedents are you hoping to set as a result of, pursuing what you're pursuing here? Like, we talk about like, you didn't do it right the first time. There was kind of this legal gray area prior. We're going to engage in this suit and, set these boundaries. Like what kind of boundaries, expectations, or limitations are you hoping to kind of put against these platforms, so they start like acting in the interest of artists and rights holders benefit?
Yeah, or otherwise just letting people, if they want to be a part of it and they want to use your music, opt in, and then you should get paid. You should get paid an ongoing royalty. That should be a future thing that you get to benefit from. But what I would like to have happen is that we've seen certain courts, and I would like our courts to do this, is that it's not fair use. In these specific circumstances, again, when you have a business, that's it. It's just a business that's trying to do its little businessy thing and build tech. When you're going to go and take something to create a product that is an exact lookalike, in those circumstances, this is not fair use. And you need to go and pay. You need to go do licensing deals. And then, on the flip side of it, access is a big thing. Courts that even have found that maybe AI training is fair use, they at least carve out and they go, but the way that you access it is very important. If you go to pirated websites and you're doing it in a real shady kind of way, again, not fair use. And that's what I want to see, across the board, but particularly in our cases.
Moving forward from here in terms of like what the industry is looking like in the immediate future, another thing that has just come up and I think is maybe going to be some kind of game changer, you let me know. In the wake of this lawsuit settlement with a couple of the majors in the midst of all of this AI generation nonsense, we've also seen all of them sort of like strike this kind of licensing deal with this Clay platform, where it sort of seems like the major labels are now going to agree to essentially having their works incorporated in, licensed with, used by in some capacity by this Clay platform that I presume on some level, I don't know how much research you've done into it, is going to be doing exactly the same thing. You punch in some prompts. I want it to sound like this, maybe this artist, maybe this genre, and give me the song that I am asking for here. What do you feel like this kind of deal, inking this sort of deal, is going to do for the industry, for what Suno and Udio are doing, what's happening with your lawsuit, just all the legal ramifications around all of this? Like, what do you foresee as a result of this deal?
Well, the way I'm going to use this, just like with the 11 Labs deal that it did with Cobalt and Merlin, is just to say that there's, already ways that other businesses, other AI companies are doing this ethically. You just come up with a deal and you figure out a path forward. So it didn't have to, this whole like what AI companies used to say, we had to do it. It was going to be too expensive. We have to do volume. It's too wild out there. We got to just take what we take. And that's not a good argument, because we see that it can be done properly. And in fact, I am not anti-tech. I am not anti-AI. I think that if anyone wants to sign on and say, use my music, I want to get paid for it, great. Have an avenue and everyone should just opt in. That's it. I want consent. I want people to know what's going on with the stuff that they have spent their time and effort to create. So anyway, where I'm curious about with Clay, and I'm stalking them out just to see if I can start a conversation, is I just go, what about independent artists? It's the same thing. I needed us to have a seat with all of these infringements that happened. I didn't want major labels to be the ones that took up the pitchfork, did the fight, got the result, and then once again, independent artists are left without any remedy.
Right.
And so with now new deals, I go same thing. Right now, I don't have a list of all the independent artists that we represent, meaning just like everybody in the tens of millions. I go, that's a problem. I want to think through that so that I could come to Clay and just be like, for the people who want to be a part of this, who want to do something like this, how do we do it? So I'm thinking through that. And then on the flip side, if you don't want to be a part of this, you should have that option.
Speaking of which, in terms of this, recent major label deal and another potential, kind of like legal gray area here, do you foresee the artists on these labels being able to, or having the ability in their contracts to where if they don't want, let's say, for example, The Weeknd, if he says, or Drake or whatever, say, I actually don't want my music incorporated into this whole Clay thing. Do you think they'll have the ability to sort of say no there, or will they have to be sort of like wooed in some way financially for it to happen? Or do you think the labels are just going to be like, well, this is our shit, so we're just going to basically, give it to this company to further, kind of maximize profits off of what you've done for us because we're the rights holders?
Wooed. What a good word.
Thank you. Thank you. I always try to be on my best, vocabulary behavior with you.
Yeah. So look, and it's a big question that I have, because I know that most of the contracts that they, have with these artists, predate AI in general. And so they probably don't have AI provisions. And so going to each person and getting informed consent is a mild nightmare. I understand that, but sorry, that's what you need to do. And so what they're probably doing, and I have seen this, is that they're just putting in that sneaky AI language. And so you have to be careful. This is where I'm like advocating, have someone who knows what they're doing. A lawyer in the entertainment industry is really good before you sign the thing, because it will say, we get to use your voice. We have permission right away. And then it's like, on page 40, clause number 120. And so you're going to miss it. So just, it's an uphill battle from both sides. But just what I care about the most is for artists, protect yourselves. Know what your contracts say and have a contract.
Yeah. Anybody signing a new contract, a contract from here forward, especially with any of these groups, like you do need to scan anything that you're signing for any kind of AI based language, because you want to know what you're sort of like, consenting to.
Yep. And actors too. I'm obviously I'm an entertainment attorney. I just super duper love music. So that's why I do top music attorney. But in my realm of just, working with actors and filmmakers and things like that, this is something they have to be careful with as well, because upon your demise, do they get to just use your voice in new movies later on? Like, you got to pay attention to the stuff that's in your contract.
Miss Crystal, I appreciate you taking the time and, just speed running this conversation with so much information. I just feel like you're such an open book, and anything I need to know, you tell me, and you give it to us straight, and you put it so well. I appreciate it.
Hey, well, I love to woo your audience here, so I'm trying my best. And I promised at the very beginning that I would say, if someone wants to get signed up for the lawsuits, because what's going to happen, and what I'm kind of fearful of, to be honest, is that what we've seen in other cases, there's a settlement, there's a class certification, there's whatever. And all of a sudden there's this time crunch and they're like 30 days to get your list. And right now, again, if we have millions of people who were harmed, people knowing about this is now the number one thing that matters. And so anyway, it's a little form. It takes like 3 minutes. Go to topmusicattorney.com, fill it out so I have your contact information. That's all I need.
Okay. And again, thank you for wooing my audience, because Lord knows I have a difficult time doing that on my own. Thank you guys very much for watching. I know, big, dense video, but important topic that we must address. Shout out once more to Miss Crystal. You can find her in the description box down below, either on Instagram or on her website. And over here next to my head is another video that you guys can check out. Hit that up or the link to subscribe to the channel, and I will see you in the next one. Anthony Fantano, Suno, AI, lawsuit, forever.